This is a lecture on trade secrets protection in Singapore. 新加坡商业秘密保护. Courts across different cultures have evolved rules pertaining to trade secrets protection. And you find that courts play a key role in determining the nature of trade protection in Singapore. 这也强调法院在社会的重要性. There's an important point I'd like to emphasize that justice delayed is justice denied. 我在上海政法学院谈过这一点. If you bring a legal dispute pertaining to trade secrets to Singapore, it will be dealt expeditiously by the courts. 一个国家如果要成为国际贸易、商业和经济中心，法院肯定要保护商业秘密。Unlike other countries where trade secret protection is enshrined in a statute, in Singapore it is not. It is within the field of intellectual property law, but it is dealt with by the courts. 也就是说，在新加坡没有特定的法规。Trade secrets protection is via common law principles of contract and equity. And very importantly, and that's the case we'll discuss later, on the doctrine of the breach of confidence. 也就是说，通过普通法的合同和衡平法则原则. Now the case of I admin provides a clear example to the meaning of the breach of confidence. 也就是说，违反了保密的规定. It is a case that you should read in the original version. You look at the anatomy of the judgment, you will find that the courts have dealt with on the breach of confidence and also in reviewing the breach of confidence in the original case itself. This is a judgment delivered by the Chief Justice himself. 这是 I admin 的判决. How do you assess for the original judgment of I admin? Go to the internet, look for www.singaporelawwatch.sg, and when you are there, use the search function and enter the case citation SGCA 32. 如何查阅新加坡 I admin 案例的判决呢？你就在 SLW 网上收录这案例的英文 SGCA 32. Singapore trade protection is grounded on court precedents and case law, so the doctrine of precedent will apply. 也就是说，法院的先例很重要。也就是说，新加坡的商业秘密保护的方法最重要就是判例法为基础。Without standalone legislation on trade secrets for protection, the courts themselves have provided robust protection through key judgments in cases. 如何处理商业秘密？在新加坡，你必须看关键的案例，他们的判决就提供了强有力的保护。 Here we discuss on how companies should protect their confidential information, and this comprises of agreements, non-disclosure agreements, as well as through employment contracts. 也就是用这个保密协议和雇佣合同来保护秘密。There are three elements in protecting trade secrets within Singapore. Three key elements， 就是三个主要的要素。And from these three elements, assessment of these three elements, that will determine if a legal claim on the breach of confidence has a chance of succeeding within Singapore courts. 能不能胜诉是个大问题，那就要看违反保密规定的诉赔。Firstly, it is the confidentiality of the information. In other words, there must be efforts taken to maintain this secrecy. 也就是说，公司必须努力的保存这个秘密，不能给公众所知。So before the information is conveyed to the person, it must be made known to him that this is confidential and not to be disclosed. And this is best done through a non-disclosure agreement. But it is not absolutely necessary. It may be inferred from the circumstances of the case. 也就是说，没有 NCDA 也可以上诉，要看实际的情况如何。最妥当的还是有一份 NCDA. Before you have a claim, there must be evidence of an unauthorized use or disclosure of the confidential information. Unauthorized use. And that use have caused or maybe a potential harm to the information owner. 在未有授权的时候使用或露出这秘密。Now we look at a few notable cases. This Turf Club Auto Emporium case is a key case in Singapore that clarifies breach of confidence. And the main facts are the plaintiff had an auto mall selling automobiles, cars, and he shared his confidential plans with the defendant. And the defendant set up an alternative company to compete. And this sort of case happens often in business when someone takes someone else's plans to do a competing business. 这种情况很通常你在市场上可以见到，就是一个人拿别人的商业秘密计划而进行竞争。Turf Club Auto Emporium case is interesting for the fact that the court specify what needs to be present before information is considered or plan is considered to be confidential. Namely, it has to be specific and be of value, and information must be communicated in situation that imposes this confidential obligation upon the defendant. 法院呢认为这三点很重要。第一点呢就是那个信息必须具体，第二点要有价值，而很重要的就是在沟通这信息的时候有信任的 任意。If those criteria are satisfied, then the court would decide in favor of the plaintiff when the plans are used without consent. 最重要的是这一点，就是被告必须拿到原告的允许，才可以使用这些秘密的资料。Deng Sui Choi is a case that is illustrative of what is happening in business world all the time. The stealing of someone else's customer. 就是说，应用这个客户的数据资料。The court made a very important point, and that is implied duty. There is implied duty not to abuse the use of information acquired confidentially. 在这情况下，法庭说产生了一个漠视的义务。Invent Pro is a case that elaborate and illustrate that proprietary technical details and designs are trade secrets. So the use of such technology to develop new products, you need to have the approval of the person who owns that technology. 也就是说，技术是一个秘密的商业品，技术呢会受到法庭的保护的。Here we discuss on legal protections and remedies available. Top of the list, I put that injunction. That is, you can get a court order to prevent further misuse or a disclosure of the confidential information. 这里我们就谈到法律保护和补救措施。第一就叫法院下警令，避免更多的滥用或泄露机密的信息。虽然这不算是赔偿，可是呢，这避免更多的损害。Next, we have the heading of damages. Now, damages is compensation for losses or harm caused by the breach of confidence. Later, we shall discuss the computation of these damages. 这也是法官最重要的保护方式，那就是赔偿。下一回我们会谈到怎么计算这个赔偿，就是这个损害赔偿的数目会要多少，应该多少。The court may order what they call delivery up. That means the person is required to return or to destroy any copies of the confidential material. 法院可以命令那个被告要他归还或者销毁机密的材料。Then the plaintiff may claim for an account of profits. That is, where the plaintiff can get the money that is earned by the defendant through the wrong use of the trade secret. 如果被告获得利润，我们说是利润账户，那么法庭可以多取这笔钱还给原告。Then there are statutory provisions to which the plaintiff may be able to access to in order to remedy the situation when there is a trade secrets violation. Thus, if the material is covered by Copyright Act, then clearly the plaintiff can resort to this Copyright Act for protection. This may be particularly relevant for software codes or designs. 原告可以以 版权法来保护他的商业秘密，特别是软件一类式的产品。Under Penal Code, Singapore Penal Code, Section 378, any theft of information, and that include trade secrets, could be prosecuted if there is a criminal, emphasize criminal misappropriation of the property. 在新加坡刑法第378条，盗窃信息可以被起诉。A very common method is where companies will get employees before employment to sign non-disclosure agreements as part of the contract. If an employer breaches confidence, then the employer will pursue the matter through civil litigation. 在这方面呢，雇主经常依赖雇佣合同中的保密条款。If you want an insight to the employment scenarios in Singapore, you can access this book, which is actually an e-book now, and you can get it through internet. 如果你想领略一下新加坡有哪些就业场景和常见的问题，书籍被数字化为电子书，网上可以拿到。Under Singapore law, how do you quantify damages due to breach of trade secrets? 就是如何量化损害赔偿。The whole purpose of damages is to compensate for the losses suffered by the plaintiff due to the misappropriation of their trade secrets. 主要目的是要补偿原告损失，因为被告盗用商业秘密。The court, in estimating the damages, is guided by the principles of contractual law as well as the law of torts. And of course, it is based on the specific circumstances of the case. 法庭是以合同法和侵权法的原则来估计损失，而法庭要考虑到案件的具体的事实。What are some ways where damages can be assessed and quantified under the trade secrets law in Singapore? 有哪一些方式来量化损害的赔偿呢？ The actual financial losses suffered by the plaintiff can be compensated, and this includes loss of profits, lost business opportunities, and losses that arise from a dilution of the trade secret. 实际的损失包含利润的损失，还有商业机会由于商业秘密加之稀释而造成的损失。比较难量化的是商业机会，失去商业机会的损失。Now, if there is a misuse of the trade secrets, and that misuse has resulted in a loss of market share, then that will be compensated. 如果被告滥用商业秘密，而这造成市场份额的损失，这也可以算入赔偿中。Now, the courts may disgorge any profit that the defendant earned through the wrongful use of the trade secrets, or that is unjust enrichment by the defendant. 任何不当的利润，法院将为原告追回此类的利润。Sometimes the court may award damages based on what the defendant would have reasonably paid for the right to use the trade secrets lawfully. In other words, hypothetically, a licensing fee. 法庭也可以给原告这许可费。Sometimes the court may mete out what you call punitive damages. That is to punish the defendant, especially when his conduct is egregious or malicious. And then the damages will be exemplary. 如果法庭认为被告的行为恶劣，法庭就可以判这个正法性的赔偿。And finally, the court may issue injunctions so as to prevent further use or disclosure of the misappropriated trade secrets. 法庭经常会发禁令，这就避免再使用被盗用的商业秘密。Now it's time to discuss a thinking homework based on trade secrets law in Singapore vis-a-vis China. 一份思考性的作业。And the case we're going to use is a very interesting one. It is Qilu. 季利。这季利的公司我曾经研究过，就是研究这个股东加持的故事。这公司的名选得好，季利。功课的题目呢，就是中国和新加坡有何不同？还有我给上面这个参考的资料。The reference article is written in Chinese and it's very useful to give you an idea of how the Chinese courts approach the issue of trade secrets. To sum it up, when there is misappropriation of trade secrets, the court would look at the specific facts of the case to provide fair compensation. 总之，新加坡的法官会看具体的事实来判一个公平的补偿。